The suitcase is still packed. 6 months after the application, one parent is abroad, the spouse is in Portugal, and the child has stopped asking when the next flight is. The family has sent emails. They have uploaded documents. They have received one vague reply. Your case is under analysis. Here is the hard truth. Another desperate email may not move this case. A focused proof file might give a qualified lawyer something actionable. I'm Elena Vargas, and this is Portugal Rights Rebel. Welcome to Portugal Rights Rebel, episode XXX. Today, we tackle one of the most common nightmares expats face in Portugal and show you exactly how to fight back legally and effectively. Your rights don't disappear at the border. If your family is living this right now, you may be thinking, we already sent everything. What else can we possibly prove? That is the right question. Because a proof file is not a giant folder containing every message your family has ever exchanged. It is a selected record that lets another person understand the case quickly. Who are the people involved? What relationship connects them? What happened and when? What is the documented impact of continued separation? Those 4 questions are the spine of the file. Think of it this way. The law is the frame. Your proof file is what allows a lawyer to test whether your facts fit inside that frame. It is not clerical busywork. It is the bridge between a painful family story and an administratively usable record. And this episode is general education, not legal advice. Family reunification rules, documents, deadlines, and remedies can depend on nationality, permit category, relationship, the exact administrative act, and the rules in force when your case is handled. Another family's approval is not a guarantee for yours. A podcast cannot calculate your deadline. A group post cannot replace a lawyer who has reviewed the actual file. Let's put the legal framework in plain English. Portugal's Immigration Act, commonly known as Law 23/2007, includes rules relevant to residence and family reunification. That law has been amended, and the applicable requirements depend on the category and facts. At the European level, Directive 2003/86/EC addresses family reunification for eligible third country nationals in situations covered by the directive. It recognizes the importance of family life, but it also allows conditions and requires the applicable requirements to be examined. You may also hear terms such as proportionality, good administration, and procedural fairness. These principles can become relevant when an authority delays without explanation, fails to communicate, or demands something impossible or unreasonable. But they do not erase eligibility requirements. They do not automatically fix an incomplete application, and they do not tell us, without reviewing the facts, whether a particular delay creates a court deadline or a viable claim. In plain English, silence may be important, but it is not automatically an appeal deadline, a victory, or permission to wait indefinitely. That distinction protects you from 2 dangerous extremes, giving up because the office is silent, or assuming that silence means you have already won. Now open a secure folder. Give it a name that is boring and unmistakable, such as Family Reunification Current File. At the front, place a 1-page cover sheet. List the names exactly as they appear in the passports, dates of birth, nationalities, current locations, the Portuguese residence permit or application reference, and the family relationship. Use reference numbers when communicating with the authority or your lawyer. Do not post them publicly. Do not send them to strangers in an online group just because someone says they can help. Behind that cover sheet, place clear copies of the passports and relevant residence documents. Then add the relationship evidence, a marriage certificate, registered partnership record, birth certificates, or other documents recognized by the applicable rules. If a document came from outside Portugal, stop and verify the formal requirements. Is an apostille needed? Legalization? A certified translation? A specific format or recent date? These details can vary. A document can be genuine and still be unusable in the form submitted. Check with the responsible authority or a qualified lawyer before relying on it. Here is a small step that saves a surprising amount of time. Number every document. O1, applicant passport. O2, sponsor residence permit. O3, marriage certificate in the original language. O4, certified translation. Then create an index with the description, date, issuing authority, language, and document type. Original, copy, translation, apostille, receipt. This is not about making the file look impressive. It is about making a missing item visible. If someone asks, where is the proof that the application was submitted, you should be able to answer in seconds, not after an evening of scrolling through screenshots. Keep the original files in secure storage and create a working copy for submission. Preserve appointment confirmations, payment records, portal confirmations, emails, letters, document requests, and delivery receipts. If you redact irrelevant financial numbers, addresses, or information about unrelated people, make the redaction permanent. A black rectangle placed over text may not actually remove the text underneath. And do not send an entire family archive simply because you have it. Minimum necessary evidence is often stronger than indiscriminate disclosure. Protect the family's privacy while proving what matters.
Now ask yourself a harder question. Are you proving only the relationship, or are you also proving the urgency? Those are different things. A marriage certificate can show that two people are married. It does not by itself explain why continued separation is causing a medical, financial, childcare, schooling, or safety problem. What does the impact look like in your family in a way that another person can verify? Suppose the parent in Portugal sends €420 every month for rent and childcare abroad. Suppose that parent has traveled twice for appointments, missed 3 school meetings, and is paying expenses in 2 countries. Those records do not guarantee a result. They do something more modest and more useful. They explain the cost of the delay. Select representative bank transfers, payment records, school notices, travel receipts, or shared obligations. Add a short explanation of what each item shows. Do not send hundreds of unrelated transactions and expect the reviewer to interpret them for you. If there is a medical issue, ask an appropriate professional for a concise letter describing the relevant limitation or care need. Usually, the question is not, can we upload the entire medical history? The question is, what limited information is needed to understand the issue connected to the separation? If children are involved, consider childcare arrangements, school disruption, missed parent meetings, travel burdens, and the practical effect of one parent being absent. The child's best interests may be relevant, but that phrase is not a substitute for dated, specific evidence. There is a difference between saying, "This is unbearable," and showing what unbearable means in verifiable terms. A parent may be losing work opportunities. A child may be missing regular care from one parent. A spouse may be paying for 2 homes while making repeated trips that produce no answer. Write a short impact statement, perhaps 1 or 2 pages. Who is separated? For how long? What practical consequences have occurred? What remains urgent? Keep the facts dated. Avoid threats, insults, and dramatic claims that cannot be proved. Emotional pain is real, but credibility is part of protection. And please do not circulate a child's passport, medical records, or private correspondence in public groups while seeking advice. Next, build the timeline. Not a memoir. A timeline. 1 line for each important event. Date. Action. Office or person involved. Document attached. And result. For example, March 3rd, application submitted. March 4th, payment confirmed. April 20th, appointment requested. May 9th, additional document uploaded. June 1st, status request sent. No response received as of today. Keep facts separate from conclusions.
No response received is a fact. The authority intentionally ignored us is a conclusion you may not be able to prove. Save the sent email, the delivery confirmation, the full headers if available, the portal reference, the postal receipt, and the appointment record. A screenshot with no date, URL, or surrounding context may be difficult to authenticate. You are not building a scrapbook. You are building a record someone else can verify in 10 minutes. That record shows more than worry. It shows that you acted consistently, supplied information, and gave the administration a fair opportunity to respond.
Once the timeline is clear, prepare one concise formal request. Ask for the current status. Identify the application and family member. List what has already been submitted. Ask whether a specific requirement is genuinely outstanding, if that is known. Request a reasoned response or decision through the appropriate channel. And if your first thought is, I want them to fix everything, narrow it down. What do you need next? A status explanation? A missing document notice? A decision? A lawyer's review of possible remedies? One precise request is usually more useful than 5 angry messages sent to 5 different addresses. Now be very careful with legal effect. A status request is not necessarily a complaint. A complaint about poor service is not necessarily an administrative appeal. An appeal may not be the same as a court action, and an email may not be the formal method required for a particular procedure. In plain English, a status email can show that you followed up, but it may not protect your right to challenge a refusal. If there has been an express decision, a refusal, or legally significant inaction, ask a qualified Portuguese immigration lawyer to identify the available challenge, the deadline, the competent body, and the evidence required. Do not let an informal complaint use up time that belongs to a formal remedy. Escalation should be coordinated, not scattered. Depending on the facts, follow-up with IMA may help clarify a status issue, missing communication, or document request. Portuguese complaint mechanisms or the Ombudsman may provide routes for reporting administrative problems, but those channels have defined powers and limits. They may not order the result you want. They may not replace litigation. A lawyer may consider an administrative challenge or judicial action if the procedural posture and evidence support it. European Union channels are another example. A petition or complaint may be relevant when a situation raises a broader question about how European obligations are being implemented. But those channels generally do not operate as a private, fast-track appeal for one family's application. They may not suspend a national deadline. They may not compel an individual approval tomorrow. They usually cannot replace national legal advice. Those channels can expose a broader problem. They usually cannot decide your individual family application on your preferred timetable. Turn bureaucracy into accountability by choosing a channel for its legal purpose, not because it sounds more powerful. When you speak with a lawyer, bring the proof file before you bring the panic. Ask whether they regularly handle Portuguese immigration and family reunification matters. Ask them to review the exact permit category and current rules. Ask what legal question they are answering. Is it document admissibility, a status request, an administrative challenge, court action, compensation for documented damage? Ask what work is included and what is not. Document review, correspondence and appeal, litigation, translations, court costs, communication frequency, and likely stages should be discussed clearly. Request the engagement terms in writing. Be cautious with anyone who guarantees approval, promises a secret contact, asks you to sign blank forms, or cannot explain what happens if the authority responds while the case is being prepared. A competent professional can be optimistic about a strategy and still acknowledge uncertainty. That honesty is a strength. Immigration cases are fact-specific. Administrative practice changes. The lawyer's job is not to promise the future. It is to assess the present file and explain lawful options. Consider 2 anonymized patterns. One family gave the lawyer 7 core documents: a properly formatted marriage record, proof of the Portuguese resident status, the application receipt, a 1-page timeline, evidence of regular support, and a focused explanation of a childcare problem. The lawyer could see what had happened and what question needed answering. The file did not guarantee approval. It made the situation usable. Another family provided 70 screenshots, 3 conflicting dates, duplicate documents in different versions, and medical records belonging to unrelated relatives. Their distress was real. Their presentation was not reliable. The reviewer could not tell which application number was current or what result the family was actually requesting. More pages did not create more proof. They created more questions.
So what can you do in the next 30 minutes? First 5 minutes, write the names, nationalities, locations, residence category, application reference, and relationship. Next 5, gather passports, permits, civil status records, submission receipts, and appointment evidence into one secure folder. 10 minutes, build the timeline using dates, actions, and outcomes only. 5 minutes, select the strongest evidence of dependency, vulnerability, or urgency, and remove irrelevant private details. Final 5, write 1 paragraph stating the immediate result you need. Do not send it yet if you are unsure which channel is legally appropriate. Save it, verify the facts, and obtain advice where needed.
Before we finish, keep these warnings close. Never alter a date, invent a payment, hide a refusal, or submit a document you know is false. Do not duplicate applications merely to create noise, unless a qualified professional identifies a lawful and sound reason. Do not assume that a complaint, ombudsman submission, or European complaint pauses a deadline. Do not send originals unless the authority specifically requires them and you can preserve evidence safely. Do not rely on an unverified translation or missing legalization. And do not treat another person's nationality, permit, or court result as a prediction of yours. If your family is separated tonight, I know a checklist does not replace a hug, a shared dinner, or the certainty your children deserve. But it can replace helpless repetition with a record of facts, responsibility, and lawful next steps. Before you send one more message, open a blank page. Write the relationship. Write the last official action. Write the date of your last response. Write the one result you need next. That is the first page of your proof file. Then add identity, relationship evidence, the timeline, the documented impact, and secure delivery records. Ask a qualified Portuguese lawyer to test the strategy against the current law and your exact administrative history. Save this episode. Share the checklist with someone facing a family reunification delay. Use it before your next escalation, not after a preventable mistake. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case. Turn bureaucracy into accountability. The system is slow. Your preparation shouldn't be. Your rights don't disappear at the border.